The evidence is mounting up, and it's not looking good for Megan Boswell with respect to having perhaps killed her child. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. The prosecution has now been able to establish, I guess, that there are real facts that tie Megan Boswell to the crime, and they're doing that through a couple of different things. One is through fingerprints, and the other is through the testimony of the medical examiners. They put up the person who did the autopsy, and they put up a forensic pathologist on day 6. And in addition to that, they put up a fingerprint examiner who happened to do a fingerprint analysis on the foil that was covering baby Evelyn's face when she was found in the trash can. And so the cuts are somewhat long here. I'm going to summarize a little bit of this up front. It looks to me like the autopsy probably suffered from the process of decomposition that probably made it more difficult to come up with a cause and manner of death. But the forensic pathologist here, I think, tries her very best to nail down a cause of death. But first, before we get there, let's take a listen to the forensic fingerprint examiner and basically what he says about the fingerprints that he found on the trash can and on that foil.
What did you speak with law enforcement about what needed to be done further?
I did.
Okay, and if you would kind of tell us how that conversation went.
I finally volunteered to come to Bluntville and fingerprint Miss Boswell myself.
And did you in fact do that?
I did.
All right. Were these prints that you obtained clear enough that you could make some sort of analysis or identification?
Yes, they were.
All right. And did you in fact make findings in that regard?
Yes, I did.
And what were those?
I was able to identify the fingerprint from the underneath the rim of the trash can to Megan Boswell's number 2 or right index finger.
So that ties Megan Boswell to the trash can and to the lid. And of course, you have to lift the lid to put anything in there. And usually the most recent print would be the one that you would expect to find, which is apparently what they found. Had some difficulty getting it. I skipped that out of there because that was just long and involved. But basically, the bottom line is he tied her to opening the trash can. But that's not all. Listen to this.
And do you remember why that was?
Yes, part of the original packaging was a large box, and then inside that box was these other pieces as well. And this box had markings on it that looked like it was only for forensic biology. And so I ignored that box and focused on the other pieces of aluminum foil because that's what I was understanding was to be working, to be processing. That was the actual piece of evidence. I did not know that the forensic biologist had separated one piece out because she actually saw ridge detail that would be considered fingerprints. And so she actually separated that piece out and sent it separate so that nothing got destroyed or damaged. And it was my mistake that I did not recognize that that box was actually also part of the full exhibit.
Okay. And when you say the box, you're talking, it's actually in a separate, it's exhibit 203, is that correct?
That is correct.
Okay. And so you had not performed testing on that piece initially?
No, right? I did not.
Okay. After it was received back in the lab by you, did you perform testing on it?
Yes, I did.
And were you able to develop any sort of latent print profiles as a result?
I developed a couple of prints on it. One print was not identifiable, meaning it did not have enough clarity or detail to be able to use to identify to an individual. One print was identifiable, and that print I identified. You're right.
Yes, go ahead. Sorry.
My findings on that one was that it did identify to Megan Boswell's left middle finger.
So as I understand that testimony, it would appear that the foil that was around baby Evelyn's face was removed by the forensic scientists at the location, and there were two pieces of it. One that the forensic biologist recognized might have latent print detail on it, so she cut that off and kept it separately. But then, because of a mix-up, it didn't get to him until later. The bottom line was that this fingerprint tied Megan Boswell to the foil that was found around baby Evelyn's face. A pretty damning day for Megan Boswell. Then we got to hear from the medical examiner, the forensic pathologist rather, who is also a medical examiner, and she had some pretty devastating testimony as well.
Now, you are currently employed as a forensic pathologist, correct?
Yes.
And are you board certified in the area of forensic pathology?
Yes, the anatomic pathology and forensic pathology is kind of dual certification.
All right. And so what is it that you do as a forensic pathologist?
So in the state of Tennessee, actually, the forensic pathologists are medical examiners, and so because we don't have a coroner system, we have a medical examiner system. We are appointed to perform the duties of a medical legal death investigation on a county level. So essentially, that's what I do. I investigate with the help, of course, with the rest of the staff in the office. We investigate all the sudden deaths that happen, as I said, suddenly without medical attendance or due to violence. And our main obligation is to work not for any particular organization or the law enforcement. We work with the law enforcement to come up with an answer to what really happened and what the cause, manner, and mechanism of that in these situations where that happens suddenly, unexpectedly, without medical attendance or due to violence.
Dr. Mileusnic, at the request of the district attorney's office here in Sullivan County, did you review an autopsy that had been performed by Dr. Matrina Schmidt, as well as other case materials involving the death of Evelyn Boswell?
Yes.
And if you would, tell us what materials you reviewed.
So I reviewed everything that was available when I was approached to originally look at the case, and I can list all the entries that I compiled in my report if that's
Sure.
Acceptable. So what was available to me at the time of review and writing of my report is the birth certificate for Evelyn Boswell, Indian Path Medical Center birth records, Premier Pediatrics medical records, Mountain States Medical Group Urgent Care medical records, Bristol Regional Medical Center medical records, then autopsy report performed and signed by Dr. Schmidt, autopsy photographs, scene photographs, TBI forensic biology reports, several of them. They were dated from March 11, March 25th, April 22nd, and then TBI toxicology report dated March 19th, that's 2020. And then National NMS, which is the National Medical Toxicology Lab, both technology forensic case report, summary of facts by the Attorney General's office, and the presentment State of Tennessee, Sullivan County Criminal Court case S72869.
And these materials, are they typical of what you would normally review in preparing an autopsy?
Yes.
All right. And based upon your review of those materials, did you form an opinion as to the cause and manner of death of Evelyn Boswell?
Yes.
And what was that opinion?
So my opinion was that Evelyn died of asphyxial death and that the manner of death was homicide.
So now we have cause and manner of death, and we have a fingerprint tying Megan Boswell to the manner in which the infant was found. She probably didn't mean to, but she threw the defense a bone during her direct examination with this little snippet of information.
That with that respect, actual asphyxial death in general are very complex deaths, And if there is any compromise in the integrity of the person, such as decomposition, then they have to be really described in such a manner, these mechanisms, that are understandable, because in the end, the asphyxial death is the what we call diagnosis of exclusion, meaning when everything else is excluded, what we are left with essentially is that the findings in the body and the finding of the body within the scene that are going to come to essentially explain what really happened to an individual. What I'm essentially saying is that there's the asphyxial mechanism such as positional, mechanical, traumatic, or actually can be also the consequence of the positioning in the scene, and that information comes strictly from the scene investigation.
That essentially is a giant red flag waving, saying, I made this diagnosis by a diagnosis of exclusion, which means that she has to exclude all other potential causes, which is a pretty big universe of causes. So it gives some fodder to the defense for cross-examination. She now must withstand cross-examination, and Mr. Scott is not going to pull any punches here.
You can't say conclusively that she was alive when she was wrapped, yes or no.
All I can say is that she cannot breathe with a foil,
Judge, I would ask
with a
you
bag,
to ask the
bag,
witness to
and
answer
with
my
the
question,
blanket.
yes or no.
Doctor, you need to answer his questions. He's asking yes or no questions. You can explain afterwards if you want to, or if you feel the need to, but you do have to answer his questions directly.
So I'm sorry, what was the question?
You can't say conclusively that that child was alive when it was wrapped in the blanket and when it was wrapped in tinfoil.
I have no reason for this child to be dead.
Yes or no, doctor?
Nobody can tell exactly of the state of her body except that she cannot breathe with a foil and a bag and a
Judge, I would
trash can
ask
and a
the
blanket.
court to instruct the witness to answer the question, yes or no, and then explain.
I'm not really sure.
I'm not being mean to you. But he's asked you a question. The answer is either yes or no. And I'm instructing you to the best of your ability. Answer yes or no. And then you'll have an opportunity to explain.
For a forensic pathologist, it's hard to answer that question, yes or no, but nobody can guarantee or say with certainty what really happened to this child prior to the foil being put on her face.
So you can't say whether she was alive or dead, can you?
She has no reason to be dead, other than
Judge,
that.
this witness is being evasive. May we approach?
All right. Let me see if I can boil this down. The lowest common denominator. He's going to ask you this question one more time. And I understand this case and this situation. Man, I'm telling you, if the answer is not yes or no, you'll be facing contempt of court. Can I be more clear?
Yes, sir.
Ask your question.
Ma'am, yes or no, can you say conclusively that this child was alive or dead when it was placed in the blanket and the tinfoil?
The blanket, tin foil, the trash can, which one? Okay, the answer is no. She could have been murdered a different way.
Thank you, doctor.
When you get a witness who fights with you, in other words, when you say, answer only yes or no, and they ramble on before and without ever answering yes or no, the only proper thing to do is say, Judge, I move to strike is not responsive. The question called for a yes or no answer. She didn't give a yes or no answer. There was no yes or no in there. And the judge properly advised of your objection, we'll strike that answer. And then you ask the question again. And then you get the same response, you move to strike again. And you keep doing that. And here's the reason why you keep doing it. If you allow the cross-examination answer that just repeats the basis for what you don't agree with 3 times, you are drilling into the jury's head that this answer really gets your goat and that it really hurts your client. And so, as a result, this must be really important. He then forces her to say yes or no. And the problem with not having stricken that information is that it's in the record and it will be used by the jury. And on appeal, even though it's not responsive to the question, it's still in the record and it hasn't been stricken. And so there are some huge problems, if there is an appeal in this case, with those very non-responsive answers. And with respect to the jury, there is another problem. You have this tall gentleman who is standing up and he's essentially bullying this witness. Answer only yes or no. Well, everyone knows that there are lots of questions that can't be answered yes or no because they depend on variables that aren't part of the question. And so what you do is you explain that you can't answer it yes or no, and then you say these are the variables that control that. That way, you get to do what you want to do without having your answer stricken. So this witness didn't do that, and he kept coming back to yes or no. Give me a yes or no answer to this long question. And that looks like bullying, first of all, and jurors see that as very unfair. It's like, well, you're making this woman, she's not testifying, you're trying to testify through her. And actually, that's exactly what he's trying to do. He's trying to get her to admit that she can't rule out other causes and that there might be some other factor that caused this child's death. And of course, if I had been her, I might have said something to the effect of, well, there are other things that can't be ruled out because your client hid this child's dead body for so long. That might have been a really effective way to deal with this kind of bullying. But a lot of times witnesses aren't schooled in how to push back legally in this kind of situation. But I have to give him credit for at least trying to knock this down and for doing it in a manner that would have been very good if he had simply remembered to have the non-responsive answers stricken from the record. Because some appellate judge is going to say, well, I know he tried to get her to answer this yes or no, but clearly these are the facts that she believes, and she's the expert, not him. That's a problem on appeal. If you take that stuff out of the record, the judge can't rely on that. The appellate courts can't rely on it. And of course, this trial judge won't be able to rely on it if there's a motion for a new trial. So, a lot of people don't understand that being in trial is the closest you will ever come to mortal combat without having a weapon on. And it's intellectual mortal combat, and it is easy to forget these kinds of things when you are in the heat of battle. Nothing will prohibit him from coming back at a break in the trial and coming back and saying, Your Honor, I move to strike those non-responsive answers from the record. And hopefully he'll do that. But he didn't do it at the time, and the judge might not have such a good memory at a later point in time and might refuse to do that. Now, that would again be another point of error. But by the same token, if you're explaining, if you are trying to repair errors that you made through errors that the judge made, it begins to look a little desperate. So that's what I have for you today. Hopefully you've enjoyed this. Come on back tomorrow. Catch me down here at the beach. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.